The first big thing, and of course, one of the primary aspects of the landlord-tenant relationship is the payment of rent. So what rights does the landlord have as respects to payment of rent? Under South Carolina law, the landlord has the right to be paid rent on the due date. However, the Residential Landlord-Tenant Act gives the tenant a 5-day grace period for the payment of rent before an eviction can take effect. The landlord can charge late fees for non-payment of rent, and the landlord is not required to make any number of attempts to collect collect rent. If rent is more than 5 days late, the landlord, in order to have the right to evict, has to provide one notice, and that notice has to say something to the effect of, you have 5 days past the due date within which to pay your rent. If you don't pay your rent within that time frame, the landlord can seek to have you ejected or evicted. That notice can actually be written into the lease, and there's language in the South Carolina Residential Landlord-Tenant Act that the act suggests is satisfactory to that obligation. So a lot of times you will see that notice written, oftentimes verbatim from the statute, into the lease. If it's not in the lease, the landlord has to give a written notice, a letter, once during the entire duration of the tenancy. So the landlord doesn't have to give the notice every time rent is late, just one time at any point during the tenancy. Now, it often occurs that there are rent disputes. Landlord says you didn't pay, or tenant didn't pay. The tenant says I did pay, and there's a dispute as to what was paid, when was it paid, that kind of thing. It is vital for tenants to get receipts. If the landlord refuses to give a receipt, which is something that we hear not infrequently, unfortunately, the best advice I can give would be to keep a ledger. Just keep a piece of paper or anything where you write down the date, the time, the amount paid, the method of payment, whether that's money order or cash or personal check, something like that, especially if you're paying in cash, because there's no way to go back and reconstruct what was paid based on either bank withdrawals, or it's close to impossible. And if that becomes an issue down the road in court, the law says that the magistrate is supposed to determine the issue, but of course the magistrate needs evidence. And so you want to be able to give the magistrate evidence as to what was paid, when it was paid, if it comes to that. So if you can pay it by check or by money order, that's often preferable, because then you'll have a record that you can keep and you can use to reconstruct that payment history.